17 days ago. Yet the trial required by Article 11, Section 3(4) of the Constitution to proceed forthwith will begin only on June 11, dangerously close to the end of the 19th Congress. This delay compromises due process and undermines our role as an impeachment court. Under the 1987 Constitution, the Senate of each Congress acts separately and independently of the Senate of the Congress before it. Only 12 senators remain after each election, insufficient to form a quorum. Thus, unlike the U.S. Senate or the Philippine Senate under the 1935 Constitution, we cannot carry unfinished proceedings into the next Congress. Allowing the 20th Congress to take over this trial would be ultra vires or beyond our constitutional power. Jurisdiction over impeachment is exclusive to the Congress that receives the complaint. Supreme Court rulings in Neri versus Senate and Balak versus Senate and our own Senate rules, Rule 44, Section 123, confirm that all legislative and investigatory matters terminate with the expiration of a Congress. This principle is affirmed internationally. Jefferson's manual provides that unfinished business do not carry over into a new Congress. If we cannot conclude the trial before June 30, 2025, we must recognize this impeachment case is functionally dismissed by constitutional operation and no action can be taken by the 20th Congress on the matter for lack of constitutional authority. Mr. President, kahit anong pilit, hindi maitatawid, lalo na't kung lalabag sa saligang batas. Let this manifestation be entered into the official records and journal of this chamber. I will likewise submit a version of this manifestation complete with footnotes for proper documentation. I speak in defense of constitutional order, procedural fairness, and the institutional dignity of the Senate. Maraming salamat po, Mr. President. Mr. President, I move to consider on third reading Senate Bill number 890. This is the bill on the Government Optimization Act. Printed copies of the bill were electronically distributed to the members of this chamber on March 18, 2025 in compliance with the 3-day rule of the Constitution. I so move, Mr. President.
Any objection? Hearing none, motion is approved. Senate Secretary is directed to read the title only of the measure and to proceed to roll call vote.
An act right-sizing the national government to improve public service delivery and for other purposes. Roll call vote. The Honorable Senator Binay, Senator Cayetano Alan, Senator Cayetano Pia, Senator De La Rosa, Senator Ejercito, Senator Estrada, Senator Gatchalian, Senator Go, Senator Ontiveros, Senator Lapid, Senator Legarda, Senator Marcos, Senator Padilla, Senator Pimentel, Senator Poe, Senator Revilla, Senator Tolentino.
A manifestation.
The minority leader is recognized. You may proceed, sir.
So thank you, Mr. President, for giving me your permission to make this manifestation on the topic touched earlier by our majority leader, Mr. President. This is the issue of whether the impeachment complaint transmitted by the House of Representatives to this Senate last February 5, 2025 can cross over to the Senate of the 20th Congress. Well, Mr. President and my dear colleagues, doubts have been publicly expressed by certain personalities whether the trial of the impeachment complaint against the Vice President can continue or cross over into the 20th Congress. I wish to share and put on the record some of my thoughts on this particular issue. Article 11, Section 3, Paragraph 6 of the Philippine Constitution provides that, and I quote, "The Senate shall have the sole power to try and decide all cases of impeachment. Hence, this provision makes the Senate not just an impeachment court, but the impeachment court. An impeachment proceeding is sui generis, that is, unique or a class of its own. In Republic versus Sereno, it is described as a proceeding exercised by the legislative as representatives of the sovereign to vindicate the breach of the trust reposed by the people in the hands of the public officer by determining the public officer's fitness to stay in office. While the form, procedure, and substantive arguments in impeachments remind us of a court trial, it also has the characteristics of a political process. The decision-making process in impeachment is not governed by any fixed or binding standard of proof, allowing for broad discretion on the part of the members of the impeachment court when they make their final decision on the case. The decision makers or the members of the impeachment court can use any standard of proof they want, and this choice will not be subject to any review by any court except the court of public opinion, which is not technically a court. This fact gives the impeachment proceedings its political character. Hence, to better understand these sui generis impeachment proceedings, we need to look for analogies using well-known principles and practices in other systems which are applicable to impeachment proceedings. As to the question of whether the impeachment trial conducted by the Senate in the 19th Congress or the impeachment complaint entertained by the Senate in the 19th Congress can cross over and continue into the 20th Congress, there is no provision in the 1987 Constitution or in the Senate Rules of Procedure on impeachment trials that expressly prohibits this. On the contrary, the Senate Rules on Impeachment support the position that the impeachment trial shall continue until final judgment, even if it is necessary to continue into the next Congress. Let me read the rules. Rule number 3. Upon presentation of the articles to the Senate shall specify the date and time for the consideration of such articles. Unless the Senate provides otherwise, it shall continue in